Fair warning, if you thought you had any inalienable rights and freedoms, such as the freedom to leave your home, you're
Probably going to find this court order somewhat frustrating to read.
Viva Frei, Montreal litigator turned YouTuber, another day in lockdown, and another vlog analyzing a court order adjudicating on the constitutionality of said lockdown. What is going on today? Well, a group of Michigan citizens filed a lawsuit against the governor of Michigan, Gretchen Whitmore.
You're saying it weird. Why are you putting so much emphasis on the H?
Seeking, in particular, a preliminary injunction and a declaration that certain executive orders violated their constitutional rights to due process. For those of you who may not know, Gretchen Whitmore issued sweeping executive orders and stay-at-home orders, going so far as to ban the sale of seeds, which were apparently deemed to be non-essential items. People found these sweeping executive orders to be almost oppressive. It led to protests, and sure as sugar, it led to a lawsuit. And just yesterday, or April 29th, if you're not watching this vlog on April 30th, the State of Michigan Court of Claims rendered its decision on the preliminary injunction. And fair warning, for those of you who were silly enough to think that you had any fundamental or inalienable rights and freedoms, you are going to find this judgment to be very, very irritating to read. So let's read it, shall we? State of Michigan Court of Claims. Steve Martinko et al. Plaintiffs versus Gretchen Whitmer.
Say whip. Whip. Now say cool whip. Cool whip.
In her official capacity as governor of the state of Michigan, Daniel Eichinger in his official capacity as director of the Michigan Department of Natural Resources, and Dana Nessel in her official capacity as the Attorney General for the state of Michigan. Opinion and order regarding plaintiff's April 23, 2020 motion for a preliminary injunction, Honorable Christopher M. Murray. First things first, because I am a mere Quebec attorney, and if anybody doesn't know, Quebec is a province in the country of Canada, I didn't know what a court of claims was. From Chief Judge Christopher M. Murray. Welcome to the website of the Court of Claims. The Court of Claims is a court of statewide limited jurisdiction to hear and determine all civil actions filed against the state of Michigan and its agencies. The Court of Claims operates much like any other Michigan circuit court. In the Court of Claims, however, there is no right to a jury trial. All right, that's interesting. So now we know what the Court of Claims is. There is no trial by jury, so now let's continue reading with this judgment. Introduction. This matter was filed by 5 Michigan residents who claimed that 3 of Governor Whitmore's executive orders, Executive Orders 2020-21, 2020-42, and now Executive Order 2020-59, infringe on their constitutional rights to procedural due process and substantive due process. Specifically, plaintiff's verified complaint alleges that the mandatory quarantine imposed by EO 2020-59 violates their right to both procedural due process and substantive due process, and that the intrastate travel restrictions contained in EO 2020-42 also violate their rights to procedural due process and substantive due process. They also allege in count 4 of their verified complaint that the Emergency Management Act is an unconstitutional delegation of legislative power to the governor. Plaintiffs have requested the court issue a preliminary injunction, but not a permanent one, restraining these defendants from continuing to implement the provisions of EO 2020-59. Once restrained, plaintiffs seek a declaration that the challenged restrictions and the EMA are invalid. It's something we've talked about in previous vlogs, the nature of injunctions. There are various types of injunctions. The names will vary depending on your jurisdiction. The idea is that the emergency injunction carries you over to the interim injunction carries you over to the final judgment, and the final judgment can order the permanent injunction. The defendants to the suit, that being Gretchen Whitmore and the other defendants, raised the issue of absence of jurisdiction of the Court of Claims. Defendants first argue that this court lacks subject matter jurisdiction because plaintiffs seek only injunctive relief based upon federal constitutional claims, which deprives the court of jurisdiction to decide the matter. Defendants rely upon MCL 66440, which provides. And because I didn't know what MCL was, I had to Google it, and it stands for Michigan Compiled Laws. And wait until you read this piece of legislation. No claimant may be permitted to file claim in said court against the state, nor any department, commission, board, institution, arm, or agency thereof who has an adequate remedy upon his claim in the federal courts. But it is not necessary in the complaint filed to allege the claimant has no such adequate remedy, but the fact may be put in issue by the answer or motion filed by the state or the department, commission, board, institution, arm, or agency thereof. Translation? What the Jokes aside, the comprehensible translation of this piece of legislation is that if the plaintiff has a claim that can be brought before the federal court, they are precluded from bringing that claim before the Court of Claims, and they must bring it to the federal court. The defendants are telling the court that the court lacks jurisdiction to adjudicate on the matter. It must refer it to the federal court and cannot adjudicate on the merits of the motion. Now let's hear what the court thinks of it. The legal principles put forward by defendants are sound, but they do not apply to plaintiff's case. First, the statute refers to claims filed in the Court of Claims against the state, its departments, agencies, etc., and does not pertain to claims brought in this court against individuals as plaintiffs have done here. Thus, it is irrelevant whether claims against state officers in their official capacity brought in federal court might essentially be considered claims against the state. Second, with respect to defendant's argument, plaintiffs seek declaratory rulings on each of their three challenges, and one of those challenges, the claim that the EMA violates the separation of powers doctrine, is based upon state law. So too is their challenge to interstate ban on travel to vacation rentals. The simplified version of this reasoning, although I'm not entirely sure I agree with the reasoning, is that the statute provides that if you're suing the state and you have a federal claim to do so, then you have to go to the federal courts, but they are not suing the state, they are suing individuals, even if they are suing those individuals in their official capacity as representatives of the state. The court also concludes that they have subject matter jurisdiction because the lawsuit will likely involve state laws, so the state court is best suited to adjudicate on it. Now, some people might be reading this decision and saying, oh look, the judge just dismissed one of the arguments raised by the defendants, this is going very badly for the defendants. While others might look at this and say the judge wants to retain jurisdiction so the judge can control the outcome of this lawsuit. Given the reasoning in this judgment and the outcome of this judgment, I think everyone's going to come to their own conclusions. Then we have some discussion about the purpose and objectives of injunctions, the criteria that need to be met in order to obtain the issuance of injunctions. It's stuff we've talked about in previous vlogs, but we'll go over it briefly. The objective of a preliminary injunction is to maintain the status quo pending a final hearing regarding the parties' rights. When deciding whether to grant an injunction under traditional equitable principles, a court must consider 1. The likelihood that the party seeking the injunction will prevail on the merits. 2. The danger that the party seeking the injunction will suffer irreparable harm if the injunction is not issued. 3. The risk that the party seeking the injunction would be harmed more by the absence of an injunction than the opposing party would be by the granting of the relief. And 4. The harm to the public interest if the injunction is issued. Alright, that is all the boring legal procedural nonsense. Let's get into the facts at issue. Michigan residents, like all other Americans, cherish their liberty. We always have, though the liberties and freedoms we seek to protect have changed over time. I can hear some of you screaming through your computer screens, yes, some liberties have changed over time, others haven't, such as, the fundamental and inalienable ones. But let's see where this judgment is going. At and before our founding, our forefathers fought for the inalienable right to own property, freely engage in commerce, represent ourselves through our own elected representatives, worship where and how we wanted, etc. The Declaration of Independence's list of grievances against the King of England prove as much, as do several of the amendments to the United States Constitution, and in particular, the 5th and 14th Amendments. Today, we have all the freedoms and liberties that the founders fought for, and our branches of government exist in large part to ensure that those rights remain intact. The liberty and freedoms at stake in this matter do not in large part involve those rights and liberties our founders fought so hard for. Instead, plaintiffs focus on the right to freely move about one's community and state, to do commerce when one pleases, and to travel about the state for vacation purposes. It is the restriction to those activities within EO 2020-59 that plaintiffs challenge here. And then the judge goes on to describe the evolution and spread of the Maasai in Michigan and ends with the following paragraph. At the time the first stay-at-home order was issued on March 23, 2020, only 13 days since the first confirmed case in the state, there were already 1,328 confirmed cases and 15 deaths. Today, just over 1 month later, Michigan has over 36,000 confirmed cases of the virus and over 3,000 related deaths. And at this point, given the judge's framing, we know darn well where the judge is going. I mean, we knew darn well before because we read the headlines, but now we know where the judge is going. In their complaint, plaintiffs do not challenge the governor's authority to issue the executive orders on this subject matter. Instead, plaintiffs challenge the scope of the order through separate claims based on procedural due process and substantive due process. Although these claims entail different considerations and standards, the court will address the claims together since under these circumstances, each protected right is subject to the same overriding principle. In other words, the constitutional right asserted does not make a difference when considering this issue because both are subject to a balancing with the state's interest to protect the public health. This holds true because, and perhaps contrary to common knowledge, most, if not all, individual constitutional rights are not absolute and are subject to a balancing with the countervailing state interest. Most, if not all, individual constitutional rights are not absolute. End of story right there. The judge then goes on to astutely point out that constitutional rights do not become less important under exigent circumstances, but then goes on to say what I think is going to offend a great many people. Though our individual constitutional rights cannot be suspended or eliminated, they are, as noted, subject to reasonable regulation by the state. So I'm gonna just make sure I understand the reasoning here. Individual constitutional rights cannot be eliminated or suspended, but they can be regulated by the state even if that regulation entails the elimination or suspension of those individual constitutional rights.
Gotcha.
In addressing this argument, it is imperative to recognize the limited question the court is empowered to decide. Except in limited circumstances mentioned later, it is not for the courts to pass on the wisdom of state action that is granted to it by the general police power or by statute. Certainly, the state cannot simply ignore the individual rights enshrined in our federal or state constitution in the name of public health threat. Judicial review of state actions is therefore and quite obviously appropriate and necessary. But the depth of that review is limited and does not include delving deep into the pros and cons of what is the better plan of action between two reasonable alternatives. The circular reasoning in this judgment reads like a dog chasing its tail. Americans and Michiganites, Michigan. People from Michigan love their liberty. Although Americans have individual constitutional rights that cannot be suspended or eliminated, they are nonetheless subject to regulation by the state. One cannot blame someone for reading this judgment and coming to the conclusion that they basically have no rights that the state does not bestow to them. And in determining whether to issue the preliminary injunction, the court comes to the following conclusion as to the likelihood of success on the merits. Binding authority from the United States Supreme Court and the Michigan Supreme Court compels this court to conclude that plaintiffs do not have a substantial likelihood of success on the merits. That is not because the rights asserted by plaintiffs are not fundamental, being forced, with some important exceptions, by the state to remain in one's home, in turn causing many residents to be unable to work, visit elderly relatives, and to generally move about the state. But those liberty interests are, and always have been, subject to society's interests. Society being our fellow residents. They, our fellow residents, have an interest to remain unharmed by a highly communicable and deadly virus, and since the state entered the Union in 1837, it has had the broad power to act for the public health of the entire state when faced with a public crisis. The role courts play under Jacob and Lansing is not to, quote, second-guess the state's policy choices in crafting emergency public health measures, but is instead to determine whether the state regulation has a, quote, real or substantial relation to the public health crisis and are not, beyond all question, a plain, palpable invasion of rights secured by the fundamental law. Plaintiffs suggest that the better and more constitutionally sound decision would have been to quarantine only those who have the virus. It may have been a better option to some, as doing so may have had a less severe impact on the movement of the Michigan population, and may have reduced unemployment. Or, as plaintiffs argue, a more narrowly tailored order by region may have been more reasonable for the entire state. Alright, sorry for that interruption. We were having a kid who was having something of a meltdown, and he is now sleeping in the back of the car, so I'm gonna have to finish this vlog at a slightly lower tone. The court then goes on to outline the state's serious considerations when determining these executive orders and the objectives of these executive orders, and comes to the following conclusion. And contrary to plaintiffs' arguments, the Supreme Court has upheld against a constitutional challenge a state's quarantine of individuals even when they are not infected with the disease being controlled. As noted, the court's role is not to pick which alternative may be more reasonable, more preferential, or more narrowly tailored, as the latter is in deciding some constitutional cases. Monday morning quarterbacking is the role of sports fans, not courts reviewing the factual basis supporting executive action to protect the public health. What the court must do and can only do is determine whether the governor's orders are consistent with the law. Under the applicable standards, they are. I don't understand the reasoning of the court, and it bothers me. And when I say I don't understand the reasoning of the court, it's not in this stubborn, childish sort of, I don't agree with you, so I don't understand what you're saying. It's that I don't understand the logic behind the reasoning because it seems to be circular, if not contradictory. Americans have fundamental individual constitutional rights. Okay, these fundamental individual constitutional rights cannot be suspended or eliminated, but they can be regulated even if the effect is a temporary suspension or elimination of those rights. Okay, the courts are not there to assess or pick the best course of action that the government ought to have implemented. Okay, the only thing the courts can and must do is determine whether or not the orders are consistent with law. Okay. But here what the judge is in fact saying is that these executive orders do in fact infringe on the individual constitutional rights, but they are justified in the name of the public interest. Okay, I presume that if the court comes to the conclusion that between two alternatives that the state could have implemented, one being unconstitutional and the other one being constitutional, the court would have to strike down the measure that was unconstitutional. In this particular case, it's not about the court usurping the power of the government and choosing from equally constitutional remedies. I don't know if this decision is going to get appealed, if there's going to be the opportunity for the decision to get appealed, but to me it sounds like a decision that should be appealed. It's not up to the court to draft the regulations for the government. It is specifically up to the courts to ensure that any regulation that infringes, suspends, or eliminates an individual constitutional right is drafted as narrowly as possible. And if it is not drafted as narrowly as possible, strike it down, send it back, draft it again. Plaintiffs also challenge the constitutionality of the Emergency Management Act, which the judge promptly dismisses as follows. Plaintiffs' challenge to the delegation of power from the legislator to the executive will likely not succeed. It is certainly true that the legislator cannot grant some vague, unfettered discretion discretion to the executive to carry out what is a legislative function. But if the challenged legislation contains sufficient guidance to the executive on how to execute the law to further the legislature's policy, it does not violate the non-delegation doctrine. And then with respect to the harm to the public interest criteria, which we saw at the beginning of this vlog, the judge writes as follows. Finally, and for many of the same reasons, the court concludes that entry of a preliminary injunction would be more detrimental to the public than it would to plaintiffs. Although the court is painfully aware of the difficulties of living under the restrictions of these executive orders, those difficulties are temporary, while to those who contract the virus and cannot recover, and to their family members and friends, it is all too permanent. That is not to say that every new virus will require the action taken here, but given the authority of the governor to do so in the face of these circumstances, the court must conclude issuing injunctive relief would not serve the public interest, despite the temporary harm to plaintiffs' constitutional rights. For these reasons, plaintiffs' motion for a preliminary injunction is denied. And this closing paragraph, with respect, illustrates what I feel to be the fundamental flaw in the judge's reasoning. The judge basically says that it's not every time there's a virus that the government is going to have to implement these kinds of measures. And the precedent set in this judgment is that when the state does do that, it's not up to the courts to second guess or play Monday morning quarterback, even if those measures are in fact unconstitutional. Because we do have to be clear here, the judge did not come to the conclusion that the measures implemented by Michigan were constitutional. He said that the unconstitutionality of those measures was justified in the public interest. And that rationale can pretty much apply every single time the state says the public interest so justifies it, and the court's going to say, well, it's not up to us to second guess what the state decided. Oh, jeez. How's my sleeping beauty? Did you have a nice power nap? Are you laughing? Alright, this vlog is over. If you like my content and you like my videos, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. Pinky out. If you want to support the channel, all of these support links are in the pinned comment, but above all else, take care of yourselves, stay safe, stay sane, and now you know your vlog. Peace out. Booyah.